So welcome to today's webinar on Biodiversity Net Gain with speakers Chris May and Mehta from House Percival. I'm Scott Adele and I work with Fish Sherman, and I'm also the current Vice Chair on the East Midlands RTPI Regional Management Board. House Percival are a firm of expert planning lawyers who work across a range of sectors, including in planning and development. We originally planned this as a physical event for regional members. However, given the circumstances, this was cancelled at the last minute. The format of the event means it translates well into a webinar with a big positive. We're now presenting to a national audience with attendance significantly exceeding our expectations. There are a few housekeeping points to help you get the most out of the session. Attendees have been muted. If you have any questions, then please send these via the questions box in the GoToWebinar panel. This is normally at the right or top of your screen. The speakers' presentations will last for approximately 40 minutes before we come to questions and answers. I will pick a few questions from those submitted to be answered, and any questions not answered will be considered after the session and answers emailed to all participants. The webinar is being recorded and will be available on the RTPI YouTube channel after the event. So if you lose connection to the session, then please try rejoining via the original link. And if you're on Wi-Fi, this may be improved by disconnecting other devices. If in the unlikely event the speakers lose connectivity, then please wait in the webinar and keep an eye on your emails in case we have to relaunch the session with a new link. So a bit about our speakers. Chris May is a partner at House Percival with extensive experience coordinating contentious and complex development proposals across a range of different sectors. He is an expert in the field of planning law and a legal associate of the RTPI. Chris will be providing details on Biodiversity Net Gain and alongside its aims. Jay is a director at House Percival with significant experience in all areas of planning law. He is recommended in the Legal 500 and works mainly within the large-scale residential and commercial sectors. As a judicial review specialist, he has successfully defeated countless challenges to planning permissions, many of which are key cases on matters such as EIA and appropriate assessment. So now I'll hand over to our first speaker, Chris.
Thank you, Scott, for the introduction, and good morning all. So today, as you're aware, I'm talking about Biodiversity Net Gain. The presentation will cover two main areas. Firstly, which I'll cover, is the background to the Environment Bill and a summary of the biodiversity objectives and gain in planning. And then my colleague Jay will talk about the practical implications for development projects and how such measures may be secured. So, although Biodiversity Net Gain has been around for many years, it really came to the fore in the government's 25-year environment plan in 2018. And the fundamental principle is that it is to leave the environment in a better state than we found it. And to do this, they are to embed an environmental net gain principle for development, with the environment at the heart of planning and development to create better places for people to live and work, and to establish strategic, flexible and locally tailored approaches that recognise the relationship between the quality of the environment and development to enable us to achieve measurable, which is key, measurable improvements for the environment, i.e. environmental net gains, whilst ensuring economic growth and reducing costs, complexity and delays for developers. So it comes back to the fundamental balance: protect the environment, but obviously ensure that we can still grow the economy. As I said earlier, it's not a new concept, and indeed it is in the National Planning Policy Framework to some degree. Paragraph 170, bullet D, planning policies and decisions should contribute to or enhance the natural and local environment by, inter alia, minimising impacts on and providing net gains for biodiversity. And then at 175D, when determining planning applications, LPAs should apply the following principles. Opportunities to incorporate biodiversity improvements in and around developments should be encouraged, especially where this can secure measurable, that word again, net gains for biodiversity. So I think one of the key difference between the policy and the emerging legislation is that the NPPF just talks about net gains. It doesn't talk about a quantum of net gains, which I'll come on to later. Of course, the principles are also established in many local plan policies, which are currently in force. They usually require some sort of biodiversity net gain and the application of the mitigation hierarchy. In terms of the actual wording, clause 90 of the bill, biodiversity gain as a condition of planning permission, sets out that in Schedule 14, the provisions for biodiversity gain to be conditioned to planning permission in England. So it only applies to England, not Wales or Scotland. Schedule 14 itself inserts a new section 90A and Schedule 7A into the Town and Country Planning Act 1990. And the effect of section 90A is simply to give effect to Schedule 7A, where all the detail is contained. And that states that the grants of planning permission are to be subject to a condition to secure that the biodiversity net gain objective is met. So what is the biodiversity gain objective? It's set out in paragraph 2. The biodiversity gain objective is met in relation to development for which planning permission is granted if the biodiversity value attributable to the development exceeds the pre-development biodiversity value of the on-site habitat by at least the relevant percentage. And the first point to note is that as drafted, it does not apply to planning permissions granted by development order, urgent Crown development, or other developments specified by the Secretary of State in subsequent regulations. So obviously development order, that includes permitted development. So as it stands, it doesn't apply to permitted development rights. So the biodiversity value attributable to the development is a total of, firstly, the post-development biodiversity value of the on-site habitat, the biodiversity value in relation to the development of any registered off-site biodiversity gain allocated to the development, and the biodiversity value of any biodiversity credits purchased for the development. So what's there on site, whether you've sought to compensate off-site, and whether you've sought to buy biodiversity credits. Currently, the relevant percentage is 10%, so you need a 10% increase in the value, pre and post-development. And the Secretary of State has the power in subsequent regulations to amend the paragraph so as to change the relevant percentage. So in the future, if the Secretary of State wants to increase the relevant percentage above 10%, it can do so by regulations rather than new legislation or primary legislation. So in terms of calculating the value and the metric used for it, paragraph 3 sets out that the value is calculated in accordance with the biodiversity metric, which is a document produced by the Secretary of State for measuring for the purposes of the schedule only, so it doesn't apply outside of this, the biodiversity value or relative biodiversity value of habitat or habitat enhancement. The pre-development value is assessed at the relevant date, which is either the date of the application for planning permission, which is granted, or the grant of a planning permission where no application is required. But if the LPA and the developer agree, it can be an earlier date. Now, I was struggling, first of all, to understand why you'd ever agree an earlier date with the local planning authority, but it seems that it could be appropriate in circumstances where you have an earlier ecological survey, for example, and you date the pre-development value as at the date of that survey. Paragraph 5 is subject to provision whereby deliberate reducing of value before the relevant date is to be disregarded if activities that reduce that value are not carried out in accordance with planning permission or any other planning permission specified by Secretary of State in regulations. So this is effectively to address a concern which was raised that as soon as this legislation was starting to be put in place, people would go onto their land and deliberately destroy the biodiversity value with a view to making it easier to increase that value subsequently. Now, the interesting thing about this is that it does appear to include activities which are not normally controlled by planning permission. For example, removal of hedges and the like, and those activities can be disregarded if they were deliberate act aimed at reducing the value of the site. The pre-development value of biodiversity gain sites which are on the register is calculated by the value on the relevant date plus enhancement recorded plus the enhancement recorded on the register. So if you're seeking to develop a site which has previously been allocated as a biodiversity gain site, then you don't just look at the value of the site as it is, but you have to look at the value of the site as it should be if enhanced. And the post-development value is the projected value of the on-site habitat at the time development is completed. Unsurprisingly, if it's increased in value, then you add that to the pre-development value. If it's decreased in value, then you subtract it from the pre-development value. Paragraph 9 sets paragraph 8 is subject to the requirement that the habitat enhancement is maintained for at least 30 years after development is completed, and that must be in compliance with a condition on the planning permission, a planning obligation, or a conservation covenant. Now, conservation covenant is a local land charge, which is to be agreed usually between the landowner and the local planning authority, although it could be a different body, to ensure that the enhancement is secured for at least 30 years. Paragraph 10 deals with the registered offsite biodiversity gains, and that means any habitat enhancement where it is required under a conservation covenant or planning obligation, and the enhancement is recorded in the biodiversity gain site register with the biodiversity value of the registered offsite biodiversity gains measure under the biodiversity metric in relation to the development to which it is allocated. So basically, if you're offsetting your or seeking to rely on value from an enhancement site off-site, then you need to the value is how it's recorded in the biodiversity gain site register. Paragraph 11 deals with biodiversity credits, which are defined as in the clause, and these were quite controversial in that there is a perception that effectively people can destroy the local environment by simply paying a sum to the Secretary of State. But it is currently in the draft legislation, so it looks like it's being carried forward. And under it, the Secretary of State can make arrangements by which a person who is entitled to carry out the development of any land may purchase a credit from the Secretary of State for the purpose of meeting the biodiversity gain objective. So in terms of where the Environment Bill currently is, it is subject to be reported from the Public Bill Committee by the 29th of September. It is expected to come into effect by the end of the year, and as it stands, there is likely to be a transitional provision of 2 years. There was a speech last week by the Environment Secretary where he stated that a paper was imminent setting out how the approach to targets on biodiversity are to be secured and to ensure that they're established by October 2022. So it looks like that 2-year transitional provision from towards the end of this year is still the programme. So what happens in the meantime? Obviously, until the Act is law, then it is of limited relevance, and planning applications have to be determined in accordance with the development plan unless material considerations indicate otherwise. The emergency legislation can be given weight, but as I say, until it is actually enforced, and then I don't expect it to be given too much weight. The local plan policies are the starting point. If they say you need to provide a net gain, then to comply with that policy, you will have to do so. The usual considerations apply though. Check that they're up to date and consistent with the NPPF. And an important concept or important aspect of that is that the NPPF only requires at most to minimise impacts on biodiversity and to provide net gain. It's not prescriptive, and importantly, it doesn't say that you have to provide a 10% net gain. It just talks about a net gain, which in my view is a plus 0.01%, for example. And another issue which I am facing at the moment is where the local plan doesn't specify which matrix to use. There are competing matrices. DEFRA is proposed by the government pursuant to the Environment Bill, but I am aware of other matrices such as the Warwickshire method, and in one case using the different matrices results in very different figures. The case I'm dealing with, it's about 1.6 or 1.8 million based on DEFRA compensation or offsite enhancement, but on the Warwickshire matrix it's more like 3 million, so it can be a big difference. And in terms of which is the right matrix, in the absence of the local plan specifying, then it is a matter of judgment. The other thing to bear in mind is, and it comes back to this point about whether the net gain is simply just gain rather than a specified figure. If you go above that policy net gain, you are going beyond the policy, and it is no longer simply necessary to comply with the policy, but you are providing a benefit. And Jay will come on to the talking about issues with giving weight to benefits which are contained within a Section 106 agreement, but it's just one point to bear in mind in the current period whilst we are awaiting the coming into force of the Environment Bill. Talking about Jay, that gives me great pleasure to pass on to him, who will go through the more practical implications of the Environment Bill.
Morning, thanks very much, Chris, and good morning all. As Chris has outlined, I'm going to talk through perhaps the more practical implications around the Environment Bill and biodiversity net gain, and really how do we envisage biodiversity net gain working in practice. And in answering that question, there's two main issues to explore. First of all, what item is to be secured, and secondly, the mechanism, and traditionally, that's planning conditions versus planning obligations. There is, of course, a third mechanism, which, of course, is the conservation covenant that Chris has touched upon. But I'm going to be focusing more around the more traditional methods of securing planning mitigation effectively, planning conditions and planning obligations. And two tangents, if you'll allow me, I'm just going to touch upon why stop at 10%? And how can we use biodiversity net gain in order to boost the benefits in respect of a particular development project, and finally avoiding planning obligation pitfalls. And there's numerous examples. One particular one I'm going to touch upon, which is a welcome reminder about drafting robust Section 106 obligations when dealing with biodiversity net gain objectives, but also indeed any other mitigation that's required to be secured through Section 106. So firstly, practical implications, the items to be secured. Well, as Chris has outlined, a pre-commencement planning condition will be imposed on most planning consents to secure a biodiversity gain plan. And that plan will include how the biodiversity objective is achieved, namely the 10% increase in biodiversity value pre and post development. And there's three components by way of a reminder: the on-site habitat, any biodiversity gain allocated to the development from off-site projects, or alternatively the biodiversity value of any biodiversity credits. And of course, biodiversity credits, we will receive further details about how they are to be purchased and the mechanics of such through further regulations. But as I see them, as I envisage them at the moment, it's very much focused on perhaps national pooling of funds to deliver biodiversity improvements more at a national level, and perhaps not so much on a local level where other methods and mechanisms, which I'll come on to, may be secured in order to secure biodiversity net gain in those circumstances. So calculating biodiversity value, well, as Chris has outlined, there's a number of perhaps competing matrices, but so far the Secretary of State appears to be preferring DEFRA's biodiversity metric 2.0 calculator, more appropriately known as just the DEFRA matrix. And I've included a link on the slide so you can have a little bit more of a detailed look in terms of how that operates. But at first blush, it's a simple calculation. Biodiversity units created, which is what we're trying to calculate, of course, and that's calculated by post-development biodiversity credits minus the baseline biodiversity credits. So pretty simple stuff, actually. Well, maybe not. This is a summary of the DEFRA calculation. And you'll be pleased to know that I'm not going to work through it line by line and apply it to a particular development project, because quite clearly there's a lot that goes into this, and quite clearly detailed input would be required by ecologists and perhaps a mathematician of some sort in order to figure out and calculate the biodiversity credits and ultimately what the value is between pre and post development. So in terms of the mechanism very much depends on which component of biodiversity value we are trying to secure. And of course, the Environment Bill will essentially impose a planning condition already upon relevant planning permissions to secure the biodiversity objective and the 10% net gain. And effectively, a scheme would need to be provided in order to secure that, and details agreed pursuant to that scheme. But of course, there's other mechanisms that need to be considered, depending on whether, for example, on-site, off-site or financial contributions will be provided in order to meet this 10% net gain objective. And before considering these further, the PPG, the Planning Practice Guidance, reminds us of sort of two core principles when we are dealing with mechanisms to secure essentially planning mitigation. First and foremost, a planning condition, which could include, for example, agreement of a scheme, as we've already seen envisaged through the Environment Bill, will be preferred. And in a situation where you have a form of mitigation that needs to be secured in respect of a development project, and in a situation where a planning condition can achieve the same objective as a planning obligation or Section 106 agreement, then a planning condition is to be preferred. And of course, from a developer and indeed a local planning authority perspective, a planning condition is favourable, and it's favourable because there's more readily available mechanisms to amend or vary that planning condition, either through Section 73, for example, or in respect of non-material amendments and application under Section 96A. Contrast, however, with planning obligations, and planning obligations cannot be varied within the first 5 years, unless, of course, the developer and local planning authority agree. We're all familiar, I'm sure, with the use of Grampian conditions. And Grampian conditions are more traditionally imposed to secure off-site delivery of works. And essentially, prior to commencement of development, prior to occupation, a scheme will be agreed for off-site highway works, or indeed it could be in this instance off-site biodiversity improvement. In exceptional circumstances, Grampian conditions can of course be used to secure payment of monies, but traditionally that would involve a requirement to agree a Section 106 planning obligation in order to secure those sums prior to commencement, or indeed prior to occupation. So what is the right mechanism? Well, as I've outlined, that very much depends on what is being secured in terms of meeting this biodiversity objective. If, for example, it's the developer to provide the biodiversity measures, so for example, on-site provision of SUDs, wildflower meadows, for example, green roofs, so on and so forth. Or, for example, if wildflower meadows and such like are to be provided off-site by the developer, then that's something that can easily be covered off within the biodiversity scheme through planning condition in the usual manner. If, however, financial contributions are to be secured, then ultimately those financial contributions will need to be secured through planning obligation most usually. And whether, for example, a Section 106 obligation is required to secure the payment of biodiversity credits from the Secretary of State will have to be seen, but more traditionally Section 106 can be used for payment of monies to the local planning authority to deliver biodiversity improvements to the required level elsewhere within the district, and of course can pool obligations from other development projects to provide something of greater value in the sum. Thought would also need to be given as to whether or not conditions and Section 106 obligations are discharged or agreed on a site-wide or phased basis. Does the 10% net value relate to site-wide? I suspect it does, but there ought to be, I suspect, a mechanism to allow, certainly for the larger, more strategic projects or multi-phase projects, for biodiversity net gain to be calculated on a phase-by-phase basis, So if phase 1, for example, provides 15%, then phase 2, in crude terms, would only be required to deliver 5% because the site as a whole would still meet its 10% net gain objective. But that's something that we may well get further detail on through regulations, and indeed will need to be structured through planning conditions in section 106 in the right way. There's quite a lot of concern, I think, amongst us and our clients and local authorities in terms of, is the 10% net gain objective going to prevent development projects from coming forward? And of course, if, for example, it's always the case that off-site provision to be provided by the developer is required in order to provide this 10% net gain, well, of course, how does that sit with existing land deals, for example? Is the relevant land secured and off-site land secured? What does that do in terms of viability and so on and so forth? And I think that's why it's helpful so far that there is an acknowledgement that, you know, on-site or off-site provision can be provided, and there's nothing that suggests that financial contribution, for example, paid to the local planning authority, is not something that that's prohibited, and it may even be something that in practical terms should be encouraged to ensure that biodiversity net gain can be provided at a district-wide or local level through financial contribution, and of course avoiding the need for a developer to find additional land in order to provide it. And this is something that we're seeing in a number of authorities at present. And to give one example that's sort of on my desk at the moment, but a scheme for circa 200 units in Cambridgeshire with a local plan requirement to provide biodiversity net gain. The net gain in terms of percentage isn't specified, and I of course agree with Chris that could mean 0.01%. But what we've agreed in that situation, using the DEFRA metric, is a financial contribution, and the ecologist has calculated a circa 4-unit loss of biodiversity across the site, and 4 units need to be provided. 4 units need to be provided in order to not only mitigate the loss on the site, but also provide, in effect, 10% net gain. And that's been secured through a financial contribution through section 106, roughly at a cost of £10,000 to £15,000 per unit. So with a 4-unit scheme, we're looking at sort of £40,000 to £60,000, which you know, may not in most circumstances make a scheme more viable, or certainly can be palatable to developers and indeed local authorities in getting schemes off the ground. So the first tangent, if I may, why stop at 10%? And I'm sure there's many of us that would think, well, you know, as a developer, the 10% should be seen as a maximum threshold. And in most cases, you know, I've certainly got a lot of sympathy for that particular approach. But we're all familiar, of course, with the section 38.6 exercise and indeed how all planning applications must be determined in accordance with the development plan, unless any material considerations indicate otherwise. And there are circumstances, and we see it in the context of affordable housing and other green infrastructure and so on and so forth, where additional planning benefits are provided in order to tip the balance in favour of granting planning permission in the event where, for example, there may be some conflict with the development plan. And I see no reason why biodiversity net gain cannot be used in a similar context. And why, for example, more than 10% net gain cannot be provided in order to tip the balance, so to speak. And there's two sort of things that we need to be careful of here when thinking about whether on a development project we want to use net gain, biodiversity net gain in such a manner. And they're quite simply the legal tests surrounding entering into planning obligations and indeed the imposition of planning conditions. And I've set them out in full, but essentially Regulation 122 of the Community Infrastructure Levy regulations confirms that planning obligations may not constitute a reason for granting planning permission unless they're necessary, directly related to the development and fairly reasonably related in scale and kind to the development. The imposition of planning conditions is similarly worded, precise, reasonable, and relevant and necessary to the development to be permitted. And this particular issue and potential conflict with, well, I want to provide or over provide on planning benefits and how that sits with the legal tests and whether or not it's something that can be taken into account in the decision making was quite helpfully, I think, grappled with in the Amstel Group case. It's a couple of years ago now. But the principles remain valid, and I consider remain a very helpful summary in terms of how we can grapple with this particular conflict. And broadly speaking, this case concerned a Secretary of State appeal decision dismissing planning permission for a hybrid scheme of circa 200 units. The developer statutorily challenged that decision on a number of grounds, one of which included a challenge to the inspector's conclusion that the delivery of a new school attracted no weight in the decision-making process. And the inspector reached that conclusion on the basis that the school to be delivered as part of this development, well, it was land provision, the land for the school was to be provided plus a sort of circa £300,000 contribution. The inspector concluded that because that new school, once delivered, would not only mitigate the impact of the development, so 50 pupils were to be generated from the 200 new homes, but the school would mitigate not only the impact from those 50 new pupils, but also circa 150 new pupils, not only from the development, but elsewhere. And on that basis, the inspector concluded that Regulation 122 was not met, and it couldn't constitute the planning obligation that secured the land and secured the financial contribution, couldn't constitute a reason for granting planning permission because it was over and above what was necessary for that scheme to consume its own smoke, so to speak. And in a nutshell, the High Court in Amstel disagreed and simply said that the inspector was right to reach as a matter of planning judgment that the Regulation 122 test was not met. But he shouldn't have stopped there. And he shouldn't have stopped there because the delivery of the new school effectively was included in the description of development. The development included that provision. And therefore the inspector should have attached weight as a planning benefit to the delivery of that school. And weighed that in the balance and quashed the decision on that basis and returned the appeal back to the inspector for redetermination because the court was not satisfied that if he had attached weight to the benefit of the new school, that it would have still meant that planning permission would have been refused. So I think the takeaway point here in due course for us and our clients is if we are over providing from the 10% net gain, if we are over providing 10%, then that's something perhaps that needs careful thought. And do we, for example, need to restructure descriptions of development and what precisely the scheme that we're applying for to make specific reference to the biodiversity net gain measures to stop us falling foul of the relevant legal tests and indeed allowing the local planning authority to take those into account as part of the balancing exercise. And finally, I'm just going to touch upon some common pitfalls when drafting Section 106 agreements. And I'm going to focus in particular for a couple of minutes on the Spenhill Developments Secretary of State decision. It's a 2017 decision, but it is a wonderful, and I say wonderful for unfortunately all the wrong reasons, a wonderful example of how to get a Section 106 agreement really quite wrong, and perhaps a welcome reminder of some of the things that we need to bear in mind when indeed securing biodiversity net gain obligations, for example, or indeed any other type of planning obligation or mitigation. And by way of a brief background to this case, it was a high value residential-led development in Kingston upon Thames. A called-in decision from the sector, or called-in application by the Secretary of State, concerning sort of circa 700 homes, lots of commercial space, retail space, etc. And it's useful here to sort of set out the council's position on life, and the council and the applicant, in the usual way that you would do for a hearing or public inquiry, agreed a statement of common ground, and that statement of common ground confirmed that the development plan was complied with. Not only did it confirm that the development plan was complied with, but the council agreed that there was material considerations in any event that would justify the grant of planning permission. And not only did the local authority agree all those things, but they also agreed quite categorically that planning permission should be granted, even though, irrespective of whether or not there was a 5-year land supply deficit or not, and whether or not the presumption in favour of sustainable development, paragraph 11, NPPF balance was engaged. So basically, the local authority folded and just wanted planning permission on this site to be granted. So as you read through the decision, you think that this is a slam dunk, frankly, for the developer. So shock, horror, planning permission refused. And it was refused on one ground only, a defective unilateral undertaking that was provided by the applicant to secure the mitigation measures that were needed to make the development acceptable. And the sector stay, rather embarrassingly for the applicant, went through some sort of 27, 28 paragraphs, working his way through the unilateral undertaking, and found a load of errors, and then were from as fundamental as not having all of the landowners bound. Various obligations were suggested to be made, for example, by a particular phase 7, but there was no phasing plan that was currently submitted, so it could be foreseeable that there's only 6 phases in development, and therefore that obligation would not need to be paid, and therefore the mitigation not secured. Viability was equally strangely structured because of reference to particular phases of development that may or may not come forward. There was a strategic roundabout that needed to be provided as part of the scheme, and a very hefty financial contribution was being made. But that financial contribution was completely dependent on the issue of a notice, or a commencement notice, as it was defined by the local authority, but there was no definition of commencement notice. It was also dependent on the local authority covenanting to pay any unspent monies of the financial contributions. So in the event that the local planning authority didn't agree to do that, none of the obligations would have been payable. So the inspector had absolutely no certainty that the mitigation that would be required to mitigate the impact of this particular and the large development project would ever come forward. So there's plenty of other examples, but it's just a welcome reminder, just to end, that when drafting 106 agreements and indeed agreeing heads of terms when dealing with biodiversity net gain provisions, particularly in the early stages when we're finding our way through the regulations and exactly how this is to operate in practice, but also other forms of mitigation, just careful thought is always required. So that concludes my presentation. Thank you very much all, and I'll hand over to Scott to share the questions. Thank you.
Thanks, Chris and Jay. I found that really useful. I feel like it's quite a noble concept, with the ultimate aim of being an improvement to biodiversity without trying to undermine economic growth. But like many, I do have anxieties about how it was going to be managed and implemented in practice, and keen to make sure that effort is these real enhancements, but this should not undermine growth or further overstretch planning services. We do have a number of questions, so this is now the opportunity for you, Chris and Jay, to respond. So the first one I have is, how are local authorities going to deal with biodiversity technicalities that the Environment Bill will introduce? With already overstretched resources and planning officers having limited biodiversity knowledge, and many may struggle to understand the full scope of the result of the biodiversity metric output. So how are local authorities expected to deal with that?
Well,
I'll take that if that's okay, Jay. I think it's a common problem for local authorities. Resources very stretched. I think you have to expect a professional report to be submitted by the developer's ecologist, who will be prepared in accordance with his professional or her professional body, and you have to rely on their expertise. With that, you'll have the council's own ecologists, if they have one in house, or have the ability to outsource it to a local ecologist. But it is an issue for local authorities. Planning seems to be getting more expensive, not just for developers, but also for local authorities in terms of time and resources and the amount of documents they have to work through.
Excellent, thanks, Chris. Is there anything you want to add to that, Jay?
No, I completely agree. I think as things become more complicated, it's just more incumbent, I think, perhaps on applicants to guide as best as possible local authorities through these issues. And in addition to an ecology report, do you have a separate section, of course, in a planning statement, for example, that works through the Environment Bill and almost guides the local planning authorities into that decision making and sort of working a little bit more collaboratively on things? So yeah, that's all I would add. Thanks, Scott.
So the next question relates to that, but also includes the additional work for applicants. So once enacted, it seems as if it could result in quite an amount of additional work for applicants to demonstrate the metrics, percentage of net gain, discharge conditions, prepare plans, also more work for local planning authorities and their advisors to properly assess and judge evidence, advice to monitor performance. The concern raised is whether or not LPAs are already under those considerable pressures and rely on a joint ecology resource and adding additional burdens to applicants and the preparation, consideration, determination, planning application, and once permitted, the implementation of schemes, and obviously there's the ongoing monitoring as well. How do you see that playing out?
Well, I think it's a similar point. I think it is an additional resource. I think ecology assessments are part and parcel of most development schemes nowadays. Very rare that you don't need a major scheme or any scheme really to not be accompanied by ecologist appraisal. It's another piece of work that the ecologist will need to do, biodiversity impact assessment. And the monitoring is an interesting point. It will depend on which way of securing it is secured, whether it's condition, whether it's covenant, or whether it is a obligation. But it will be similar to how those are monitored and enforced against, if necessary, as is currently in practice. Onus on the local authority to ensure that people are doing what they agreed to do, and there could be obligations to help the local authority out by monitoring, for example, every year to give an update. I think that would be a bit onerous, but you could have a 5-year period, or even at the end of 30 years, to show how what you said you would secure in terms of enhancement has been delivered.
Thanks, Chris. So the next question is about, it's still not clear on when to take into account habitats that have been cleared, managed before an application is submitted. When assessing pre-development biodiversity value, some activities could be directly connected to use or management of land, for example, mowing the grass, ploughing a field, but some have no connection with the use of land, for example, removing trees, hedgerows, stripping grassland, topsoil, and could therefore be seen to be deliberate. But most of these don't need planning permission or other consents, unless, for example, a TPO or hedgerow regs, etc. And how far in advance of an application being submitted would clearance or habitats be considered to be deliberate, or is it only clearance that takes place on designated sites, local wildlife sites, and above or on all sites?
Well, it's an interesting point. I think it is a point where there is a lack of detail as it stands in terms of how far back you can go. My view is that if it's permitted development rights, or so for agricultural is a prime example, then clearly works could be undertaken which have the effect of reducing the value and which would not fall foul of these requirements or these ability to disregard those works in the draft bill. In terms of other works which don't need planning permission, it is interesting because ordinarily the Town and Country Planning Act deals with things which require development and isn't concerned with aspects of activities or works which don't comprise development. If you're clearing hedges, unprotected hedges, mowing the lawns, all that stuff could fall within activities which are designed to deliberately reduce the pre-development value. But it's how far you go back. That's not. There's no detail on that now. So that, as it stands, if there is no detail, it will be a judgment.
Thanks, Chris. Anything to add, Jay?
No, not particularly. I mean, the only slight point, I think it comes back to evidence, and if works have been undertaken for agricultural purposes or other purposes before submission of a planning application, another section in the ecology report to explain why what was undertaken was necessary and wasn't almost a deliberate attempt to reduce or artificially reduce the biodiversity value on the site. But as Chris says, without further details or guidance, we're still a little bit in the dark as to how that's going to operate.
Thank you. So, and the next one is there a scale and type of development to which requirements will apply, or is it just across the board for anything that requires planning permission?
As it stands, the exceptions are urgent crown development and permitted development. So as it stands, it's across the board.
Excellent.
But,
and
sorry, I should add that
there
is a express power for the Secretary of State to reduce it further by regulation. So
okay, so things could change.
I would expect it to change, to be honest, because it would be a bit of a nonsense, in my view, to have, for example, someone putting a new house in their garden to have to go through this exercise.
The next question is, what should be included in a local for biodiversity net gain? I think that's meant to be a local plan for biodiversity net gain.
Do you want to take that first?
Sorry, Scott, can you?
Yes, so what should be included in a local plan for biodiversity net gain?
In a local plan? Yeah, I mean, I think that, again, we're a little bit lack on detail at the moment, but I see no reason why you can't have strategic biodiversity sites. They're effectively promoted, I say promoted, but effectively promoted through the local plan process to mitigate impacts, or and to provide the 10% net gain objective in respect of development allocations across that local plan that's being promoted, in a similar way that we see for example, SANGs, another sort of more strategic open space and green space at present. But unfortunately, it's another one, Scott, that a little bit light on the detail at present. Indeed.
I've got a question here about, they've noted the 30 years being referenced. This is from the presentation. I think this still remains the case, but could that change? Could it be in perpetuity that the enhancement has to be retained?
In theory, I think it would be difficulty to have in perpetuity, but I think there's no reason why things can't, those timeframes can't be changed. But I wouldn't expect. I think the government has arrived at the 30-year figure as a reasonable period, and I wouldn't expect that period to change. It's a long time in planning terms, or it's a long time in general, but it's a long term. It's definitely a long time in planning terms.
Excellent, thanks, Chris. Anything to add, Jay?
No, nothing from me. Thanks, Scott.
So we've got a query over when does the net gain need to be delivered? Is this before, during, or after development?
So, I can tackle that, Chris. But I think at the moment, it's a bit like a lot of these things at the present, isn't it? There's no detail or specifics as to exactly when that needs to be delivered, but that'll be something that's agreed through the scheme. So if you're providing on-site provision or indeed off-site provision physically, then you will agree, as I see it, a timetable for that delivery with the local authority. And I see no reason, because we are providing a net gain, why that perhaps can't be pushed into later in the development project. Contrast, for example, with skylark mitigation, where the impact is created almost immediately on commencement, then the alternate replacement skylark plots, for example, need to be provided immediately. I think with biodiversity net gain, things can be phased throughout a development project, but ultimately that's something that will be agreed as part of the scheme with the local authority, as will, for example, the payments and timing for payments for any financial contributions under Section 106 for off-site provision.
Excellent, thanks, Jay. I've had a couple of questions about will the slides be available afterwards. I believe they will be, won't they, Chris and Jay?
Yeah, absolutely.
And then the last two questions. Is there a criteria that a development site must meet to be subject to the 10% again? I think we covered that earlier, and it's just anything at the minute that's not exempt, so that requires planning permission. There are no further restrictions at the minute, is that correct?
Yeah,
yes.
Yeah.
And on a similar theme regards biodiversity measures not being development, is included this, if you include that within description of development in a valid way to secure this scenario, for example, in that school example given, please can Jay elaborate his thinking here a bit?
Yeah, I think the difference, I mean, it's something that will need to be considered on a site-by-site basis, and of course what the local plan says about biodiversity net gain, what the legislation says, so on and so forth. But as a general principle, if you are, as a general principle, one can't buy a planning permission. So taking it to its extreme form, entering into a Section 106 agreement to pay a financial contribution that is unrelated to the development can't be taken into account as part of that balancing exercise. If, however, it is part of the scheme, so taking my school example, as part of the development itself, land was to be provided and delivery of a school was to be included. Because that was part and parcel of the development, it was a separate question as to whether or not that planning obligation complies with the SIL tests, or whether or not you can actually take it into account as the part of the balancing exercise. So in a nutshell, you can, if a benefit is included in the description of development, I think there's a general principle and a strong argument that actually you can attach weight to those planning benefits of delivering that mitigation or the biodiversity net gain, for example, in the description of development, because it's part and parcel of the proposal. If it wasn't in the description of development and it was just a freestanding commitment in a Section 106, for example, then I think that's where the distinction lies and where the local authority may feel that weight cannot be attached to that particular benefit in a Section 106 because it's separate and doesn't form part and parcel of the development that's going to be delivered on site, if that makes sense. Perhaps not.
Thanks for that.
But,
thanks for that, Jay.
Yeah, I think it comes back, so I think it comes back down to, are you doing more than is necessary to make the development acceptable in planning terms? By doing more or giving more biodiversity enhancement than you're required to by policy, then you would expect the starting point to be that you are doing more than is necessary to make it acceptable in planning terms. And the way to prevent your 106, which secures that benefit from falling foul of the SIL regs, is, as Jay says, is to include it in the description of development, because then it's not just about it being a planning obligation, it's about being part of the development proposed.
Absolutely.
But
and
it's a really
yeah.
poor lawyer's point, to be honest with you, because it, to me, any benefit, if the benefit is necessary to outweigh the adverse impact in accordance with planning balance, then that makes it necessary for to be acceptable in planning terms. But the court, although the Amstel case was helpful, the court seems to have accepted that if you are doing more than what is necessary in an isolated case, i.e. the policy says X and you're given X plus, then the inspector shouldn't give any weight to that plus aspect of that. But I don't necessarily think that's the right approach, but that is the approach which seems to have been adopted.
We often see it, don't we?
Excellent, thank you both. And then the final question, just very quickly, is it ever acceptable to have a biodiversity net gain sum for off-site work secured through a condition and not a section 106?
So you can, it can be acceptable in exceptional circumstances to have a planning condition that requires a section 106 agreement to be entered into to secure that financial sum. What you cannot have is a planning condition that says, for example, prior to commencement of development, you will pay £10,000 to the local planning authority. That's not something that can be secured through planning condition. Instead, what you will have is prior to commencement of development, you shall enter into a section 106 agreement to secure £10,000 payment to the local planning authority. And in exceptional circumstances, that latter condition requiring a section 106 would be acceptable. But a straight condition saying you'll pay a sum of money to the local authority by a particular date won't be lawful.
I think the difficulty is what are exceptional circumstances, and that's a very high hurdle to pass. In that scenario, what I would suggest is, if they are intent on doing it by condition, is have a condition which requires the submission of a biodiversity enhancement scheme and leave the detail out of that scheme for a subsequent discussion. And that may be a way around of having to demonstrate exceptional circumstances which are required for a condition requiring a section 106 agreement.
Okay, brilliant. So thank you both for speaking today, and for all of those who have logged on. I hope you found this webinar informative. The next RTPI webinar is hosted by RTPI Yorkshire on running an effective planning service during COVID-19. This is a free event and is on the 5th of August at 11 AM, so please book via the RTPI website. There will be a feedback survey launched immediately after the session. We'd be grateful if you could take the time to respond. So the webinar will now be closed, and thank you for your time.
Thank you.